You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello and welcome to the latest Today's Family Lawyer podcast. Today I'm joined by Natalie Sutherland, and we're recording this a week before the LexisNexis Family Law Awards, at which Natalie is nominated for Family Law Partner of the Year, which you were telling me before, Natalie, you're really excited about, obviously.
I am very excited. It's a very stiff competition in that category, I have to tell you.
It's a wonderful accolade. And you know, at the risk of sounding a bit like school sports day, to even be nominated,
I know,
is
it's amazing.
Is a wonderful success. Today's podcast, though, although we could probably talk about that, today's podcast is not about your nomination at the Family Law Awards. Today's podcast is going to be about fertility, surrogacy. We've got some case law we're going to talk about. And for me, I said to you, I'm really excited about this one because there's a huge amount to learn here. And in fairness, I don't think there's anybody better to learn it from. So thank you very much indeed for joining the podcast.
Well, thank you for asking me to be on.
We've got so much to cover, so we're going to dive right in. I'd really like, just at the outset, for you to tell us a little bit about yourself. You're a partner at Burgess Mee Family Law. You lead the modern law family team. Tell us a little bit about yourself and how you've got to the position that you're in.
Yeah, so I'm 16 years qualified, and I became a partner at Burgess Mee 2 years ago. Prior to that, I was at a firm where I was doing surrogacy and fertility law, and that was the first time I'd done that. So this isn't something that I've been doing for the whole of my 16 years. It is something that I've come to in the last 4, 5. So, but this is a real passion of mine. Prior to that, I was a young junior solicitor at Leveson Meltzer Pigott. I had 9 very happy years there. And but yeah, doing surrogacy and fertility law, it kind of turned a light on in me, I think. It followed through after my own fertility issues, and this is something I do feel really incredibly passionate about, and it's something that I love leading at Burgess Mee and bringing in all my juniors to help as well, and they love it.
So historically, one of the key issues with the Human Fertilisation and Embryology Act, which if you can sort of put your teeth in, you'll just about manage to get out, was the time limit on egg freezing and this differentiation between freezing for health and for social reasons. This issue's kind of getting attended to, but do you think that there are still grey areas in this part of the law, and particularly around infertility treatment?
Yeah, so the changing of the law for egg freezing was a fantastic campaign run by Progress Educational Trust, and that's a charity that I'm a trustee of. So I'm very proud of the work they did there to bring this to the fore, and for the government to actually change the law. So I know that this has really impacted a lot of women who are freezing their eggs, and you know, it was coming to the end of the 10 years and it not being long enough, essentially. So now at least there's no discrimination between the medical side of egg freezing and the social side of egg freezing. So that's a fantastic improvement in this area of law. But one of the main issues that I see is that the consent forms are so long and so many pages of them that mistakes happen all the time, and those mistakes can have disastrous consequences. So I know from speaking with fertility clinics that they could be up to 80 pages of consent forms for fertility patients to sign before they have their treatment. And consent is a very it's the cornerstone of our law, and it's very, very important to get right. But it seems to me that we're overcomplicating it, and that's where mistakes happen. So, I mean, if you look at the Ted Jennings case, she wasn't asked about whether or not he could use the embryos for surrogacy after her death, whereas he had been asked if she could use her sperm after death. So there was this issue about the opportunity to give consent for all these things. And there's so many different permutations of things that might happen in the future that you kind of have to really crystal ball gaze and try and think of all of these different scenarios. And I mean, I don't have the answer for it as to how it should be more streamlined, but I know, speaking to people who work in fertility clinics, that this is an onerous job for them, and then the lawyers come in at the end if there is an issue. So I wonder whether there should be a way of maybe bringing in the lawyers at an earlier stage. So, fertility treatment is not only a medical issue, but I really think it's a legal one as well, because it's a different way of creating children. And because we have the HFEA, the Act, there's different ways of creating legal parentage. So perhaps having legal advice to fertility patients before they sign their consent forms, so that they understand it and can ask the right questions. I know also from speaking to fertility nurses and doctors, they don't want that responsibility of having to explain the legal consequences of giving consent or not giving consent. So and I know going to see a lawyer adds an extra layer of cost, but it really could save a lot of cost afterwards if you get it right to begin with. So that's one of the things. And I know, the HFEA, the authority, are looking to see whether or not they can update the Act. And I know from, as I say, speaking to clinics, that perhaps consent is where they need to streamline and reform.
I know we're going to talk about education shortly, Natalie, but it does feel very strange to have a lawyer involved in a decision about getting pregnant.
If you don't need fertility treatment and you're planning to have a baby, then of course you don't need legal advice. That you will create a baby naturally and you're going to be legal parents. It's where you use assisted reproductive technology and there are perhaps third parties involved. So if you're using donor conception or surrogacy, the law is involved. So I always think it would be better to have that legal advice before you go down that medical route. And I've said this in an article that I helped with on the British Medical Journal, that perhaps mandatory legal advice, so it's a more joined up process between the medical side and the legal side. And I know that's not going to sit well with a lot of people, because you're telling people what to do, and but also implications counselling, that is something that clinics have to offer. But I know from speaking again with fertility counsellors that they would much prefer that to be mandatory. So not just that you get offered it and you say, oh, I don't need it, but actually before you can go down this road, you really do need to understand what the implications are, and you really do need to understand what the legal implications are. So go and get that advice now, arm yourself with that information, and then start the medical process.
We've recently done a podcast all about cohabitation, and there's a similar kind of debate there, isn't there? That you need to understand the implications of cohabitation from a legal standpoint, perhaps before you commit to it. And unfortunately, we've seen the government sort of reject proposals on cohabitation reform. Similarly, we've seen that the Law Commission is delaying recommendations around surrogacy law reform, potentially by sort of several months. What are the key issues surrounding surrogacy law in its current state? And sort of the extension of the question, how do you see these best being addressed by any sort of potential reform?
So with surrogacy, I know that the surrogacy professional community are really disappointed that we were not getting the reforms this month. So we were promised autumn, and even that was a delay. So we had in mind that November would be when we would see these reforms and the draft bill, but it's got pushed back to spring. So I mean, this could be as late as April, May. So yeah, we're going to be waiting a little while longer. But the main issue, of course, is that you don't have your legal parentage until you have your parental order. So when the baby is born, the surrogate and any spouse are the legal parents. And then, but if the baby will obviously be with the intended parents, they don't have the right to perhaps make medical decisions for the child if the child needs it, because they're not legal parents, don't have parental responsibility. So that's the lacuna that the Law Commission is looking to change by creating this new pathway. So provided that a lot of this, because obviously this is what they've told us in 2019 when they released their interim report. So this is what we're expecting with some changes. But that in British surrogacy journey, as long as you have ticked lots of boxes prior to conception, so your implications counselling, your contract, your criminal checks, your legal advice, all of that, as long as you've done all of that, and then you have the baby, that you are the legal parents from birth, the surrogate will then have a period of time to object, essentially. So it turns it on its head. So rather than you can't have your parental order until your surrogate consents, and that can't be given in the first 6 weeks, it's swapped so that the intended parents are the legal parents, unless within that time frame, which they haven't told us how long that's going to be yet, the surrogate says, no, I don't agree with that. And then if that happens, you fall out of this new pathway and you go back into the parental order pathway, which is currently there now. So we're looking forward to having these reforms so that intended parents have that certainty from the outset. I mean, like I say, it's not going to be guaranteed, because the surrogate should always have her autonomy to be able to change her mind. But then that would take you through the court process, where obviously the welfare of the child is the court's paramount consideration.
I suggested that we had quite a lot to go through the course of the podcast, and we could probably do individual podcasts on each of these, Natalie, so we'll have to get you back. There's a recent case where the Court of Protection dismissed the application for retrieval and storage of sperm from a man who was likely to be assessed brainstem dead within 24 hours. It's a case that you've been writing about recently, isn't it?
Mm-hmm. Yeah, so I represented the parents, so the would-be grandparents, if we'd been successful. Unfortunately, we weren't successful, and it's a very, very sad case. So the young man was 22, previously fit and healthy, and basically collapsed while playing sport. And they tried to save him, but he'd suffered a stroke. And so he was in a coma, so he wasn't dead, but he wasn't going to survive for much longer. So I was instructed on the Thursday morning, and by Thursday night, we were in the Court of Protection out of our service. And the reason for that was because he was still alive, we had this opportunity to use the Court of Protection using the Mental Capacity Act to see if the court would agree to the extraction of his sperm, because it's in his best interest to do so. Because he's 22 and a student with his whole life ahead of him, of course, he's not going to have thought about signing any kind of forms to say, if I died, I want you to be able to use my sperm. What 22-year-old thinks about that? So we were in this difficult position of his parents saying that, yes, he wanted to be a father, so we think it's in his best interest for his sperm to be extracted and for us to have the opportunity to perhaps either his girlfriend said that she would carry, or if, that was too much for her and she actually changed her mind, then they would want to try and find an egg donor and a surrogate and be able to create a posthumous grandchild. So obviously that's what they wanted, and they said that he would have wanted that as well. But without the court having hard evidence to say this is what he wanted, then it was really difficult for the court to say that this is in his best interests. But it is an application that you have to make, because different judges say different things. So you never know who might be the robust judge that says, yes, I will agree to it being in his best interests and order the extraction, and then fight another day as to whether or not you're allowed to use it, because, of course, we were in court very, very quickly. But the judge had a very difficult decision to make, because there is the right to privacy of the patient, and to not have this procedure done. It's invasive. It wouldn't be painful, because he's going to he's going to die, sadly. But it is something that the court did not have any hard evidence about what was in his best interest. But it's a devastating situation for the family. So he was his parents' only child. So at 22, he's gone, and their chance of grandchildren is gone. So so one of the things I would like actually to come out of this is for people who are either young people going off to university, perhaps think about it. Perhaps think about whether or not this is something that you'd want to do, and write that down, or tell your parents, put it in an email, put it in your will. And definitely for young people who are perhaps starting a family. I know from this case itself that people that I know who are perhaps trying for a family, who hadn't thought about posthumous conception prior to this case, are now thinking about it and having that conversation and saying, right, well, would you want me to use your sperm to create a child if you died tragically before we got pregnant? So because the HFEA will allow it if there's consent. This is why consent is so important. But what you want is for that consent to be unequivocal and clear, so that your left behind loved ones don't have to go to court for someone to decide what might be in your best interest from evidence or lack of evidence, but you've made your intentions very clear. So, but again, this is not something that people tend to think about. So I think perhaps education and talking about posthumous conception and deciding whether or not, because some people may say absolutely not. I would not want you to create a posthumous child from my sperm because I would want to be their father in life. So and of course, a left behind wife might say, right, well, I'm not allowed to use the sperm, and then after your grief and you find someone else, you can get pregnant that way. But this is a conversation to have, but you're not going to know to have it unless you've heard about something like this. So this is why it's been good that it's reported, and I know it was in the Times today. So it's not going to be, like infertility, actually, it's not going to be on your radar until, oh my God, suddenly you're having to deal with it. But if you think about it in advance and you have strong views one way or another, then best to record it so that your loved one knows what those views are.
I think this case for me highlights two interesting thoughts, really. One is there's a real challenge around urgency and speed that you've alluded to. And the other is that there's a distinction between cases where the individual is deceased and cases where the individual is still alive but incapacitous. And it's a distinction that Justice Paul makes in his decision, isn't it?
Yeah, so with the Mental Capacity Act, because you are not dead, but you are incapacitous, you can have someone to act in your best interests. And this is why we had to go to court really quickly, because there was no consent. Had he died, we just wouldn't have been able to make the application. It would have been impossible, because there's no consent. The HFEA would not have done anything. The court would not have done anything else. But because of because he was still alive, there was this opportunity for the court to say that someone else, namely his father, would have been able to sign the consent for him, and that it's in his best interest to do so. So that was our window. So then we would have got the consent, and it would have been allowed. And again, because we were there so quickly, we did say, well, we're just asking for permission to extract and store right now. The judge can decide whether or not we're allowed to use it at a later date, but we can't put this off for another date because he could die. His heart could have stopped beating at any moment. It was very, very important. We went to court really, really quickly. There was that urgency, but the judge didn't allow that urgency to colour his judgment, and just to be able to make a knee-jerk reaction perhaps and say, yes, I'll let you do this and we'll discuss it another day. He was very clear that that this is something that is quite invasive, and there was no evidence that a 22-year-old would have thought about this.
So that leads on to this question about whether urgency should be part of the reforms, or urgency should be more a part of the consideration in this, because as you quite rightly point out, a 22-year-old who's otherwise healthy and fit and all the rest of it hasn't given this any thought in any way.
Yeah, no, I mean, it's a difficult question, and I obviously will say that yes, I do think there should be a bit more of a leeway for these types of situations, but so there's this other case, YVA Healthcare, where again it was using the Mental Capacity Act, and this is a case that we referred to, and in that case it was a male and female couple who already had one child naturally and were looking to use fertility treatment to have their second child, and had already been to clinics, and this man died before they'd had a chance to start their fertility treatment. So in that case, it was much easier for the judge to believe that it is something that he would have wanted because he'd gone to a fertility clinic. So and whilst we tried to use that case to say, well, we know that he would have wanted to be a father, there was nothing to say that he'd ever, done anything more about it. For example, gone to store his sperm in a fertility clinic. But yeah, I mean, if there was a lower threshold for these types of urgent cases to allow more of an opportunity to give evidence about what this person would have wanted, then perhaps that would help in these types of cases. But I know the judge was worried about perhaps opening floodgates to allow this type of case. The consent law is there. If this is what you want to happen, it can happen. You just need to make that consent. And that takes me back to this point I made about thinking about it in advance, but being aware that you should be thinking about it in advance. So that it's a difficult one. I mean, if that had been a reform to the law, then perhaps we might have been more successful. But yeah, definitely, I think that young people and anyone who wants to start a family should be thinking about their reproductive legacy, heritage, and whether or not this is something that they might want in the future, because death is something that A, is going to happen to all of us, and B, nobody knows when it's going to happen. So it really should always be thought about without being morbid. But even with your having a will, I mean, I would say that it should be written in your will. We know there's a Scottish case that allowed sperm extraction because it was written in a will. So that even though it wasn't on a specific HFEA form, it was their wishes, their consent recorded in writing. So that to me would be a really good way of recording your wishes.
And I know education, as you say, is a real passion of yours as well, because you've launched Infertility in the City. Tell us about that.
Yeah, so that is something that I founded initially with Sumaya Uzani. She is CEO and founder of Mimosa Fleur Recruitment Search Company. And she and I got together to basically talk about our own fertility issues and how so I see it within my client base and she sees it within her client base. And her client base are women who are moving firms that because she moves the partner level mostly, and they are women who are undergoing fertility treatment but doing it in secret and worried about how this may impact their career moves. So the two of us got together and said, right, well, we've had the pandemic and we've talked loads about mental health and about well-being in the legal profession, and we both thought that this was the time that we needed to talk about fertility, that people weren't really discussing it, but we knew anecdotally that it was affecting so many people. So we thought, right, well, we're just going to put on an event. So I think from that initial coffee that we had to putting on the event, it was about 8 weeks, and we managed to get we got a venue at Sidley Austin. We had, I think, 5 panelists, either partners or associates or in-house counsel from major law firms who were all willing to come and discuss their own fertility stories. And we had about 60 odd people in the audience, and it was so well received. And then from that, we thought, and Emma Menzies was on our panel. She's a fertility at work coach. And after that first event, she approached Sumaya and myself to say, the response to this has been so amazing. I think we should continue this conversation. How about launching a podcast? Now, I love listening to podcasts. I like going on podcasts, and the idea of hosting a podcast was right up my street. So the three of us got together, and to be fair, it took us 9 months to actually get it launched. So we discussed it in the December and we launched it end of September. And it's been a real labour of love, and we've managed to get, again, fantastic guests on. Our last episode of our first season, so 8 episodes, airs today when we're recording. And yeah, and it's just been incredible actually to get to meet all these people and interview them and hear the feedback that we've had. And even prior to this podcast launching, we had a second event. So so that was in July at Stevenson Harwood offices. We had 7 panelists. We talked about becoming a family through surrogacy, through the LGBT side of things, the people of colour side of things, and how it affects maternal mortality in people of colour. So we had a real cross section, and this time we had about 120 people. So we doubled our numbers in 6 months, and a lot more men came. And I was really pleased actually to see a lot of the clerks from some of the major family law chambers that came along, because what I also think is we talk about it mostly from a solicitor point of view, but of course there are barristers, and the way that they work is completely different to us. And there is a very distinct, there is that difference, because of course we have policies at firms, we can juggle work around, but barristers can't really do that. So I thought it was really important for the male clerks to come to an event such as this, to be able to listen to people's stories firsthand, so that they can go back to their chambers and better understand if their barristers are going through this, so they can help them with the diaries. And what I also want is for barristers to be talking about it more, so that it opens up that conversation within chambers as much as it's opening up the conversation in law firms. So really, really, really proud of the work that we've been doing in this area. And Fertility in the City has also been nominated for the Innovation Award at the Family Law Awards as well. So very excited about that too.
Fantastic, congratulations. And you've got the Workplace Pledge, haven't you? Tell me about that.
So that has been launched by Nikki Aiken MP. So following on from my Fertility in the City in December, and telling people about the fertility officer work that I do at Burgess Mee, and that being picked up by the media, being asked to go on Women's Hour to talk about the fertility officer role, then that Nikki Aiken MP listened to that and got in touch with myself and Becky Kearns from Fertility Matters at Work. So we've been helping her with her fertility treatment employment rights bill, so her private member's bill that has its second reading on the 25th of November. And but that is to try and change the law so that people who are undergoing fertility treatment and having to go off for appointments and things like that can get that as paid time off, just like with antenatal appointments. So that is something that's going to protect everyone that's going through fertility treatment, so that they all employers will have to do that. But the law takes obviously a long time to change, and what Nikki wanted to do is bridge that gap. So she launched the Fertility Workplace Pledge, very much along the lines of the Menopause Workplace Pledge, so that companies, employers can sign up to that voluntarily, to say that they acknowledge that this is an issue, they want to support their employees, and they sign up to a couple of promises, and then their employees can see that they've signed up to this, and then can ask, well, where's our policy, and be supported. So so Burgess Mee and myself are proud to support that, and we have lots of other law firms that I've been in touch with, all happy to sign up to it. So it's having a real knock-on effect within my industry. And then of course there's really big NatWest, Co-op, Channel 4, all of them signing up to this Fertility Workplace Pledge. So the more big companies that do it, the more other big companies will do it, and hopefully smaller companies. So there'll be this knock-on effect that it will start to improve workplaces for employees going through fertility treatment before the laws even change. But we still do need the law to change, so that those companies who perhaps think it's not necessary for them to do it will have to.
There's a final question here about what you see as the biggest change that could affect family law. I mean, do you see anything that's going to change massively? Frankly, the legislative agenda is rather full, isn't it?
It is, and I was thinking about that question. The only thing I thought to answer it in terms of the sort of modern family side of things is the government, because we're waiting for the HFEA to set out their amendments to what they want to the HFE Act, and then we're waiting for the Law Commission to set out what changes they want to surrogacy law. But the reason why we need these reforms is because the law has not kept pace with science or with society. So we do still need this law to be put in place. And quickly. I don't know how quickly,
That's
but
a bit chicken and egg, isn't it? Because
yeah, exactly.
science moves on a lot quicker than the law.
Yeah.
The law catches up and science has already moved on again, hasn't it?
Exactly. So, and I've had these discussions with people about whether or not you can future-proof this type of law, and I think I can't see it being possible, because we don't know what science is going to change, because that's happening all the time. So the best we can do is just bring it up to date for the moment, and just concentrate on that, and then review it again in the future if it needs to, which it will.
I think the truth is, we could have done 3 or 4 different podcasts here, Natalie. We've covered so much ground, so we'll definitely have to have you back on. Thank you so much for your insight. We could talk for most of the rest of the day, but we've run out of time today. It's been great to have you on. All the very best of luck with your nomination. And as this is going to be released after your nomination, congratulations or commiserations.
Thank you very much. And thank you for having me on. It's been lovely.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Natalie. Thank you for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.